Good morning, everyone. I know that there are still a lot of people that are still coming in. We are going to start pretty promptly here. I am Michelle with O2 Employment Services, and we have Jennifer Cram and Terry Bodette from O2 Employment Services as well. And of course, the famous Jake Mangus, who I will let kick off this webinar.
Thanks, Michelle. And I'm really grateful to all of you who have registered to be a part of this webinar today. As we are the Chamber of Commerce representing businesses throughout the North State, mostly in Shasta County. We have around 900 members, and we serve our non-member businesses as well, because we hope that things like this will encourage you to consider becoming a part of the Chamber. We're grateful for our partnership with O2 Employment Services, as well as the Shasta EDC, in bringing this free webinar to you all today. The Chamber is a convener of leaders and influencers, a catalyst for business growth, and a champion for a stronger community. Those are our marching orders, and it's really why I'm excited about coming to work each day. It's to make a difference in your lives, because I know that in turn makes a difference in our community. We are also pleased to be a part of the California Chamber of Commerce, so they keep us up to date as well on all of the changes that we see coming our way, coming your way. And O2 Employment Services has been our key partner locally to bring all of that information to you in a way that's digestible and actually entertaining as well. So to turn it back to Michelle, my board member, I'm going to do that now so that she can introduce today's great presenters. Thanks again.
Thank you, Jake. And also want to give a shout out to Shasta EDC. Both Reading Chamber of Commerce, Shasta EDC have partnered continuously with O2 Employment Services for many, many years to help bring this information to you guys and make sure that businesses have the tools that they need to be successful in whatever market that may be. So we want to welcome everyone to this webinar. Thank you for joining us. We know that this takes a substantial portion out of your day, and I'm sure you guys have a lot to do. Try to make sure that you guys have all of the information that you need to do your job successfully. If you do have questions during the webinar, please put them in the Q&A. Some of those will be answered during the webinar, and then we'll do a question and answer period at the end as well. Excuse me. I did put the slides into the chat. If you do not have those, or you can't see those or access those, then please send me a message and I can email them to you as well. We will be recording. We are recording. And so at the end of the webinar, we will send out an email to all of you with both the link to the recording as well as the slides. And if you guys are interested, if you're not already getting our newsletters and you are interested in getting continual information like this in terms of updates to laws, kind of best practice recommendations, information that we come across that we feel is valuable to the business community, highly recommend that you go onto our website at o2es.com and sign up for our newsletter. I promise that we will not email you pictures of puppies, although it is tempting with the information that we get to put out to sometimes include those things, but we won't. But it's a great way for you guys to stay up to date with what's happening in the community, in the market, in the HR realm, in the staffing realm. I know Jake also has a newsletter that he puts out that's incredibly valuable for information coming out for businesses in terms of programs, kind of newest news in the community and how that impacts you as business owners, as well as opportunities for you guys to give input into what you'd like to see from the chamber and from the local business community. So I recommend that you guys sign up for those if you have not already. And now my favorite part of every webinar, where I get to introduce the real experts and I get to stop talking. So Terry Bodette is our Director of Human Resources at O2 Employment Services. She operates in a strategic role such as developing policies and procedures, ensuring employment practices are compliant with regulations, aligning HR strategies with organizational goals, and providing HR expertise to our clients. She has over 25 years of human resource and management experience that spans across multiple industries and business life cycles. Jennifer Cram is our Director of Operations at O2 Employment Services. Since joining the team in 2014, she's become certified in HR and has become focused on the HR laws and regulations and the impact that that has on our clients. With over 20 years of experience in management and HR, her passion is building relationships, helping businesses grow, and educating. Jennifer is also the past president for the North State Society of Human Resource Management. So while I know it's hard to believe because they obviously both started in their careers in HR at the age of 5, I am now going to turn it over to the real experts in the field. We hope you guys enjoy this webinar. Again, if you have questions, please put them in the Q&A. And Jennifer and Terry, it's all yours.
Well, thank you, everybody, for being here today. As Michelle stated, we know that you have plenty of other things that you need to be doing, such as running your business and all that fun stuff. However, this stuff is important as well, and we want to set you up for success and try to give you the most recent updates and keep it as entertaining as possible. As Michelle said, I'm Jennifer, and we've got Terry, my partner in crime. And listening to our bios, yeah, it sounds like we've got 45 years of experience. And that, is well, more than both of us are old. So, we'll just roll with that. I'm going to go ahead and share my screen. Let's make sure I do this correctly and we do it right. Are we good? I think so. Okay, well, very good. We're going to get started today. Thank you again, Reading Chamber of Commerce and Shasta EDC, for having us. We love our community. We love doing these kind of things. We love sharing the information. We feel that knowledge is power. And, if we have it, because we look at this stuff all the time, we're going to share it. And we want to make our community as strong as it possibly can be. We felt really empowered during COVID. And I know that sounds awkward to say, but we really did, because we were able to share a lot of the knowledge and a lot of the laws that were changing like daily. I think it was every 20 minutes, something was changing and some new update was coming through. And we were able to bring that back to the communities that we serve. We are O2 Employment Services. We are a PEO as well as a staffing agency. We are the leaders in the North State from all those aspects. We take a lot of pride in what we do and making sure we serve our clients and our communities well. We are also in Oregon, Nevada, and California. So yes, we have to understand law in all of those areas. Today, we're primarily going to just cover California law. There are a few changes in the other states that we can talk about a little bit as we get there, but we're going to stay focused primarily in good old state of California, because that's the easiest state of all to practice in and to be an employer in, right? All right, let's get started. So obviously, Michelle had already stated that the handouts are in your chat, or I think she put them in the chat. So they're in there. She's going to field our questions for us. So if you have a question, please go ahead and put it in there. She's going to field those for us. In the event that you want to ask us a question later, please feel free to reach out. Terry and I are available. We're happy to take phone calls and kind of go into any further information if need be. Obviously, we want to make sure we're clear and that, you get the information that you desire. Just a little disclaimer, we are not attorneys. We don't play attorneys on TV. We are here to provide this service and to provide the information that we are aware of. And we read through a lot of legal documents all the time, but that doesn't mean that we're attorneys and can represent in that fashion. So in the event, as always, if you have certain situations or certain policies or certain laws that apply to your business, it's always a good idea to reach out to legal counsel. You definitely don't want to do it after the fact. You learn a huge mistake or a huge lawsuit might come out of it, and it might have helped just reaching out to legal counsel in the beginning. All right, today is our agenda. We're going to talk a little bit about ourselves, which we've already been doing. We are going to give a little update on COVID-19. I know we're all tired of hearing about it. It just seems to not be going away. Here we at one point thought it was only going to be a few weeks, and here we are years later, and we're still discussing it, and our businesses have all still been impacted by it. We're going to talk about equal employment opportunity, the fun stuff with wage and hour, what employers are going to be required to pay. We're going to discuss the Fast Food Council. This applies to a lot of larger employers in the fast food industry. So we've got some recent updates on that. We're going to talk about leaves of absence and benefits, background checks and I-9 documents, those fun little mandatory required documents that you have to have on file for every employee in your organization. We're going to discuss a little bit about privacy and some of the new California laws that have changed regarding that. We're also going to bring up a couple miscellaneous statutes and court cases that might be affecting employers. We're not going to go through them all because we'd bore you to death and you would want to run down the street and head to Oregon or to Nevada as quickly as possible. And we're going to prepare you a little bit for the rest of the year. Some things that we feel are important to clients to make sure that you are up to speed and that you know what you need to have and kind of help best practices getting started with the new year. I can't believe we're at the end of January. It's crazy. All right, you already know a little bit about Terry and I. Again, we're very pleased to be here and to be representing O2 Employment Services and our community, that's for sure. A little bit about us. Obviously, I've stated we are O2 Employment Services. We have the PEO, which is a professional employer organization, which is an outsourced company that provides human resources. We do payroll, we do workers' compensation, we do benefits, we do onboarding and offboarding, we do leaves of absence, you name it. From the HR spectrum, we cover it. And we also have the staffing team as well. So we have O2 staffing, which is recruiting and making sure that employees are, employers that have a short-term need might be able to utilize those services, as well as some long-term needs. Just trying to find employees is difficult these days. But as you can see, we definitely have a team of amazing women that work really hard day in and day out. And boy, we wouldn't be able to do it without them, that's for sure. We definitely rely heavily on one another, and we are very big proponents of making sure we care about one another, we respect one another, and we work hard for one another so that we give the best results to our clients. And without them, we certainly couldn't do it. All right, so let's get this party started. We are going to get started today with COVID-19 update, Terry's favorite subject.
Good morning, everyone. Yeah, I definitely did not roll the dice right on this one. I'm sure you guys are tired of hearing about COVID-19. But as Jen had mentioned, that businesses have really had to pivot and change the blueprint and the operations to meet all the challenges these last three years. I've been in HR, as you guys know, and so has Jen, for many, many years. But boy, these last 3 years have really wreaked havoc on the HR world, just with trying to help businesses and, going through all the different regulations. And sometimes those agencies weren't always on the same page. So what we're here to do, again, is just to kind of give you an idea of where we're at with COVID-19 right now and what businesses need to do to go forward. You think about it, we went from, the 14-day lockdown to gyms, school closures, businesses having to close, toilet paper shortages. We went through isolations, teleworking, trying to figure out taking employee temperatures, vaccinations, who's vaccinated, who's not, quarantines, isolations, Zoom calls, sometimes in underwear, sometimes we saw pictures that we didn't necessarily want to see. But anyway, we've made it through this far, and now we're going to focus on, not things that we can change and not the worst regarding COVID. Some of the definitions over the last several months have changed in regards to COVID. So again, we're going to give you what currently is in place. The first definition that we're going to talk about is close contact. The employers still have an obligation to provide a safe working environment for their employees and to keep anyone that's infected out of the work environment. So several months back, close contact, the definition for that was clarified. And basically it's dependent upon the workspace that you have. There's two different definitions here. If the indoor space is less than 400,000 cubic feet in size, such as your homes, if you're in a doctor's office, a waiting room, on an airplane, the close contact would be with an infectious person during the infectious period for 15 minutes cumulative within a 24-hour period, regardless of how close they are to the infectious person. This can include people who are also living in a home with someone, caregivers, classmates, coworkers, who are in the same shared indoor space. If you're in a large space that's over 400,000 cubic feet in size, such as a retail store, warehouse, manufacturing facilities, it's very similar to the definition that they had in place for a long period of time. It's if they have been within 6 feet of an infectious person for a total of 15 minutes or more within a 24-hour period. One of the other definitions is the infectious period. And we looked at that based on whether someone's asymptomatic or symptomatic with COVID. So asymptomatic persons are the 2 days before the positive specimen collection date that they've been tested through day 10. And it's or 5 to 10 days if they're testing negative on day 5 or later. So they kind of incorporate it after day 5, go ahead and test, and then you can kind of gauge from there whether or not they're still within their infectious period. And then it's after the specimen collection date for someone who's taken their first COVID test. So typically if somebody's taking that test though, you want them to mask up when they come back to work, and I'll go over a little bit more masking requirements. But if they're negative, they were able to come back to work after that 5-day with a negative test. Employees who are symptomatic, whoops, Jen, sorry, can you go back? The symptomatic person, same things. It's 2 days before the onset of the symptoms through day 10 after symptoms first appeared. There's the 5 to 10 day, depending on if they're testing negative on day 5 or later. And then there's still the 24-hour period without a fever, without taking fever reducing medications, and also the symptoms have improved. Okay, testing requirements. Testing must be made available at no cost to close contacts. And that's except for return cases. Return cases, they've actually clarified under, we're still under what's called an emergency temporary standard for Cal OSHA and the guidelines that we have to follow. However, there is a permanent standard that's being looked at right now that the board has approved. We're just waiting for the Office of Administrative Law to go ahead and make that final for everyone to roll out what the permanent standards are. So under the temporary standards, currently a return case is someone who has had COVID within the last 90 days. Under the new standard, which will be effective for 2 years once it's approved sometime early this month, the return case would be within 30 days. Testing is still required in the event of an outbreak, and a regular outbreak is 3 or more cases in an exposed group within a 14-day period. The testing must be during paid time, which is really for wage and hour law, really important that if we're requiring testing for our employees, that we're paying them not only for the time to take the test, but if they have to get there and back to take the test as well. And the testing has to be, again, made available at no cost to the employee. The employer would have to pay for that test. And that excludes any return cases. And then it would be weekly testing after that. Employees who had a close contact must have a negative test within 3 to 5 days or must be excluded and follow the protocols, as I had mentioned previously. Outbreak provisions apply under the new standard until there is 1 or fewer new cases that are detected in the exposed group within a 2-week period. It used to be that the employees couldn't come back unless there was 0 new cases detected. Okay, masking requirements. California uses the CDC COVID-19 community levels to inform the statewide masking requirements. We've provided the link here because different people are within different industries. And so here's a resource that you can use to see what community level that we are at for Shasta County or any other counties that you may be in. Masking is required in all healthcare facilities, shelters, and detention centers when CDC community levels are at that medium or high according to this chart. Workers must also follow Cal OSHA rules for mask requirements in the workplace. That hasn't changed. And employers can obviously uphold stricter mask guidelines beyond what's required here. If masks are required by the California Department of Public Health, then again, employers need to provide that at no cost to the employee. COVID-19 exposure notifications. This was a new bill, AB 2693. Basically what this bill, it amended a labor code that was already currently in place, which went over the duties of an employer when you're actually notified of a potential exposure of COVID-19. And it extends this provision until January of next year. The main modification, actually, it worked out nice for employers. Instead of having to provide individual written notices when there's a COVID exposure in the workplace, the employer can post that on an existing employee portal, or can post it at the work site in which the employee worked. Again, we want to maintain confidentiality and not disclose any individual names. We just need to let them know that there was a COVID case in the workplace and they've been exposed. The notice needs to be up within 1 day of learning of the potential exposure. It needs to be posted for 15 days in English and also in any other language that's understood by the majority of your employees. The employers also, this is a new requirement, needs to maintain a log of the posting dates at each work site. And then within that posting, some of the things that need to be included, the date of the confirmed case, the location of the exposure, which needs to really be designated as a department, a floor, a building, or a specific area. And then how to obtain information about COVID-19 benefits, what is the company's disinfection and cleaning plan, and any anti-retaliation discrimination protections for that COVID-19 case. There's also no longer a requirement to notify local health departments of COVID cases. There is, however, a requirement if there is an outbreak, a major outbreak, and there's a portal that's supposed to be created. Cal OSHA is supposed to give us further clarification on that. Supplemental paid sick leave, as most of you know, it came, it went, and then finally it ended December 31st of 2022. However, anyone that went out prior to that was still allowed to take whatever time off that they qualified for that qualifying event. We do want to remind you, and I know Jen will go into more details too, there are some local municipalities that have requirements, whether that's paid sick leave laws, supplemental paid sick leave due to COVID, or some minimum wage requirements that you want to be careful of. So I would definitely look into, if your workers are out of town, then you want to make sure, especially in California, there's several different municipalities that you want to look into. Okay, so supplemental paid sick leave, even though we're not offering it any longer, I know some clients have opted to continue to do a portion of that, but there are some other benefits and resources that we need to make sure that our employees are aware of. There's regular paid sick leave, the California Healthy Workplace, Healthy Family Act that still applies. Some employers offer vacation and PTO. The Employment Development Department also has benefits for state disability insurance if somebody is disabled due to COVID, or paid family leave benefits if they're trying to take care of a seriously ill family member. Then there's also protections that we have to consider under leave laws in California. And California has a plethora of leave laws, and we'll go into a few changes in a few minutes regarding some of them. Family Medical Leave Act, which is the Federal Medical Leave Act, and then California, of course, we always have our own version, and that's the California Family Rights Act. But there are some leave eligibility requirements, and if they don't fall under one of those, which typically requires the employee to be with the employer for at least 12 months and work 1,250 hours, then the employer needs to engage in an interactive process and see if they can make some type of accommodation, whether that's under the American Disabilities Act or the Fair Employment and Housing Act, which is California's version. So be aware of all these different options that we should probably talk through with our employee if they're still suffering from COVID-19. Okay, there was another bill that has some requirements. If you are unfortunately cited, receive a special order, or have an action that's issued by Cal OSHA. This applies to certain health and safety postings related to COVID-19, and it also requires that There's, I believe, 7 additional primary languages that are non-English languages that if it applies to your workforce, you want to make sure that you have those postings up. The notices are prepared by Cal OSHA. They include the investigation, any violations that were found, a statement that the results of the investigation had 1 or more citations found, and then the employer has to communicate what that hazard is, and again, in whatever language the employees understand. It also needs to provide Cal OSHA contact and website information so that the employees can search the citations that were given to the business. The postings need to be maintained for 3 working days or until the unsafe condition is cleared, whichever is longer. And there are citations and civil penalties that can be assessed if employers don't meet these guidelines. COVID-19 workers' comp, AB 1751. There is a current rebuttable presumption that an employee's illness resulting from COVID-19 was actually sustained in the work environment for purpose of workers' comp benefits. This has been extended until January 1st of next year. The presumption would actually apply if the employee tests positive for COVID-19 during an outbreak and within 14 days of performing the work. An outbreak is considered 3 or more positive cases within a 14-day period, or a major outbreak is if you have 20 or more cases within a 30-day period. This presumptive, the rebuttable presumption actually applies to employers with 5 or more employees, but there's also some specific requirements for different industries and locations as well. There's a case, I think Jen brought it up last year, that we've been watching closely, and it's really important because what it looks at is not only what is the effect on the employee of catching COVID-19 in the workplace, but what if they bring it home to someone in their family? So the Seas Candy versus the Superior Court case, the employee alleged that they caught COVID-19 at work and they passed it on to their husband. And unfortunately, their husband passed away due to COVID-19. The employee sued the employer, arguing that the employer's negligence in failing to take steps to mitigate COVID-19 spread was what caused his death. The employer argued that workers' compensation benefits was exclusive to the employee. The employee was allowed to proceed with a wrongful death suit based on the employer's alleged failure to comply with the COVID-19 safety measures. The reason this is important, and we bring it up again, is because there's other cases now that have been filed for similar reasons. And those are cases against Amazon, Walmart, McDonald's, and I'm sure there's more out there we just don't know about. So it's really important that we're still taking COVID-19 seriously, not only to keep our employees safe, but also to try to mitigate any risk against the employer as well. Cal OSHA has some non-emergency regulations. As I had mentioned, we're hoping to find out more about that sometime here in early February. The board approved standards, and these are the regulations that the Office of Administrative Law is deciding upon, but you can look at the website here to get more details. Regulations became effective in January, but like I mentioned, we're still waiting for that to be finalized. Another thing that I didn't mention is that exclusion pay is actually discontinued. I went over what the close contact was, that there's prevention measures that we need to take. Major outbreaks have to be reported to Cal OSHA. Serious illnesses also need to be reported to Cal OSHA. Those guidelines haven't changed. We already have those in place, whether it's COVID-19 or if there's a major injury or illness that happens at the workplace. There's some ventilation rules that become more burdensome on the employer. So you're going to want to look at what these regulations state, which includes some HEPA filters as well. Required COVID-19 hazard prevention training continues. Part of what the regulation was is that you don't have to keep your COVID prevention plan as part of your IIPP, but you can at this point. So it's your choice we're actually recommending that you might want to keep it separate because we're still having a lot of changes navigating through. Whereas your IIPP, which is your injury, illness, and prevention program, doesn't necessarily change as rapid as COVID-19 guidelines have. But there are some training requirements. So anytime you implement a new training program regarding these hazards, if you're updating it or for new hires, you want to make sure that they're trained on your COVID prevention protocols. Okay, long COVID. I'm not sure if you've all heard of regarding long COVID, but this is a reality. Some employees, individuals are actually experiencing symptoms of COVID for up to a year and some even longer. So it now falls under the American Disabilities Act as a disability, depending on the situation of the employee. So it makes the employers required to actually go through the interactive process to see if you can actually accommodate somebody that has COVID-19. And maybe maybe that's a leave of absence, maybe that's other accommodations where they can still perform their job. But we wanted to give you some resources in case that comes up in your work environment that you could reference. Okay, and I'm going to turn it over to Jen.
All right, let's talk a little bit about some equal employment opportunity. But before I get going, Michelle, was there any questions that we need to clear up with COVID? Are we good to go? Wait till the end.
I think that there's a couple regarding COVID, if you want to address those real quick, Terry. How does the term work site apply to organizations that operate with fully remote employees? Terry, you're muted.
Sorry. I think we might need a little more information regarding that. I know a lot of employers are trying to get their employees to come back to work. So it depends on the reasoning for getting employees back to work. As long as you're providing a safe work environment for your employees, that's what's important. You may have to go through if they have certain health conditions or reasons why they can't be in close proximity to other employees, then that would be part of an interactive conversation that you're going to want to go through. But it might be a follow-up call after our call to just get some clarification as to the circumstances.
Perfect. And then the other COVID question, are the no cost provided tests required only for employees exposed at the workplace or for any close contact exposure, including outside of work?
Not outside of work. The employer controls what's within your building. So if there's a potential somebody got COVID-19 from your work environment, then you're going to want to pay for the test. But also, if you require your employees to take a COVID test at any time, then you're going to want to pay for that COVID test.
Perfect. Okay, those were the only COVID questions. Go ahead, Jen.
Okay. Hey, we're doing so good. 2 COVID questions. Usually there's like 195. So you did great. Good job. All right, let's move it right along. Okay, so we're going to talk about Assembly Bill 2188. This law is going to go into effect, well, it's slated for January 1st of 2024. This is marijuana use outside the workplace. So for those of you that are doing some pre-employment drug screenings, this is going to change a little bit in how we can handle those. So effective January 1st of 2024, the law prohibits discrimination in hiring, termination, or other employment decisions based on consumption of cannabis while off the job, so not while at work. It empowers the state civil rights department to investigate and prosecute complaints alleged unlawful practices. So this is going to be a little different than what we've been used to. Obviously, we've had cannabis illegal at a federal level, and a lot of employers, have followed that to the T, but now it's going to change things a little bit. So the law doesn't apply to employees in the building or construction trades, which is good because obviously they're working with tools, they're working with things that are a little more dangerous, or to applicants that are employed or employees hired from a position that require federal government background investigation or security clearance, which is also a good thing. Employers can still maintain a drug-free workplace, so we can still have that in place, but we just have to change the drug screening process a little bit. So it is permitted during a pre-employment or upon an employer required drug test that has found the person to have a non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. allowing employers to fire or suspend workers for possessing or using or being impaired by marijuana while on the work site. So post-accident drug screens are still permissible. Testing, employers need to figure out how to test for impairment and whether THC levels in the body indicate current use. So that's going to change the testing requirements, and the levels of probably the nanograms in which we currently test for will probably be a little bit different. So stay tuned for that. That's coming up in January of 2024. So something that's on the horizon. All right, Senate Bill 523 is a protected category has been added for reproductive health. So it amends the Fair Employment and Housing Act to prohibit employment discrimination on the basis of an individual's reproductive health decision making. It expands the required health plan coverage for contraceptives, prohibits requiring applicants or employees to disclose reproductive health decision making information. This is defined as a decision to use or to access a particular drug, device, product, or medical service for reproductive health. So we're not going to talk about somebody wanting to have a family and so forth, which we've always done anyway when we're interviewing or talking to people, but we're going to make sure we don't ask those invasive questions. All right, we have Assembly Bill 2282, which amended the bill for hate crimes. So this bill expands the definition of hate crimes in place of employment to include display of hate imagery. Employers must respond to these incidents and crimes, train your supervisors, and have policies and procedures in place to ensure compliance. Obviously, we have a plethora of things in making sure we keep the workplace safe. Just one more area that if we see something, we need to do something or say something, we want to make sure that our supervisors are trained and know what to do. All right, the fun stuff, wage and hour. So as everybody knows or should know, or your payroll company should have let you know, that minimum wage increased January 1st for all employer sizes. So it doesn't matter what size of employer you are now. It used to be if you were under 25, it was this amount. If you were over 25, it's this amount. Well, that's all changed. Now it's all out the window. Everybody's at $15.50 an hour. So that was a big increase for small employers. It is expected to increase potentially every year from here on out. It's going to depend on the CPI, the inflation rate, but it's not going to go up more than 3.5%. As Terry mentioned earlier, there's some municipalities that have separate minimum wage orders, just like sick leave laws, supplemental paid sick leave as well. If you're operating in other cities or counties around California, you want to make sure that you check those because those rates are sometimes and oftentimes different or have different requirements. But we have the Bay Area and Southern California have already had some increases go into effect and some will change in July as well. So if your employees live in those areas and they're working in those areas, they could be subject to those. There are several industries in California that are considering a minimum wage increase of $25, up to $25 an hour for healthcare workers at privately owned facilities. So this is something to keep an eye on. There are also some cities that are considering and have enacted hotel workers of a higher wages, which may result into an increase of up to $22 an hour, which is also a little bit parallels with the fast food workers bill that is on the table as well. So keep an eye out for those things, especially if those industries are subject to you. As far as the overtime exemption, the salary basis, so with minimum wage increasing, this means the minimum salary requirements have increased as well. So these are your exempt employees who do not receive overtime. So the minimum amount that these employees can receive in an annual salary is $64,480 per year. So that's double the minimum wage. That's one prong of the test that needs to be completed, as well as the duties test, which includes a whole list of different responsibilities that the employee needs to be responsible for to see if they even meet the requirements of a salary. I know a lot of times employers are like, oh, we'll just give them a title and we're going to put them in charge of an employee or two, and we're going to make them salary because I don't want to have to worry about a time card. Well, be careful because there's a lot of requirements that go around it, and it's low-lying fruit for the wage and hour claims that come in to having a misclassified employee. So there's the executive, there's the administrative and professional exemption, and salary is one part of it, the duties test is another. And even going through just the duties test doesn't mean they actually are exempt. So you really want to watch those carefully. The computer software exemption is a minimum of $53.80 per hour, which equates to $112,000, 65.20. And a licensed physician and surgeon's exemption is $97.99 per hour. Those of you that have tools that your employees, you require your employees to use their own tools. So concrete workers, or you have construction crew that goes out and they want to use their own stuff. A lot of times we see this with mechanics. They want to use their own tools, even though you might have supplied them, which you'd want to, consult and maybe talk to legal. But if the employee is required to provide their own tools, they must make at least double minimum wage. So you probably want to take a look at that. All right, the industrial wage orders have been updated for this year. One, because of the minimum wage increase, that has changed. And then there's some meal and lodgings in the orders that have changed as well. So all employers should have their IWC, their industrial wage orders updated, and they should be posted by their poster, your labor law poster that you hang up each year. You should have these specific to your industry. Sometimes it's 2 industries that you might fall into the category of. You should become familiar with those and understand what you're required to do per that industry. So those have all been updated. You can pull them offline. They're easy to search and find. Sometimes identifying what industry your organization falls under, it can be a little bit tricky. Garnishments, Senate Bill 1477. So this is going to reduce the maximum amount that wages may be subject to for a garnishment. So garnishments typically have been 25% of disposable earnings. It is now going to reduce to 20% of disposable earnings, or 40% of the amount by which the disposable earnings for the week exceeds 48 times the state minimum wage. Well, have fun with that calculation. But this is supposed to go into effect September 1st, so we still have a little bit of time, but these garnishment rules will change. Mileage reimbursement, like everything else goes up. So the IRS went into effect and changed their minimum mileage reimbursement rate to 65.5 cents. So update, I'm sure your employees have already notified you that IRS mileage reimbursement rate went up. We recommend that you follow the IRS guidelines. It makes it a little simpler because it changes often. We saw a change mid-year last year, and who knows what will happen this year. Premium pay, everybody loves premium pay, but premium pay equals wages. So you want to make sure in the event that you have premium pay that you're paying for non-compliant meal and rest periods, that these are to be considered wages. So your pay stub should be updated to reflect that. Premium pay must be paid timely, and it should be paid out, especially on a final paycheck, because you don't want to have any waiting time penalties or interest accrued on that. Premium pay is calculated at the regular rate of pay. This changed last year. It really clarified how to calculate the regular rate of pay. And if you're not doing that, you probably should take a look at your pay practices and making sure you're up to date on how to calculate premium pay. All right, wage transparency. So Senate Bill 1162, this is a 2-part bill that has gone through. One, it amends the paid data reporting. So this applies to private employers with 100 or more employees, and employers who have 100 or more employees hired through labor contractors within the prior calendar year. So if an employer falls under both criteria, they must submit separate annual paid data reports regarding the contracted employees. So that's a report that's due. I'll go over kind of the specifications and timelines for that. There's also the pay scale disclosures and postings. So this is for job postings. Employers with 15 or more employees nationwide are to provide a pay scale for all position in the job postings. So if you're posting online or you're using a third-party vendor, you want to make sure that you have a salary range or at least some salary information on what the employee can expect to be paid. So in regards to the paid data reporting, the first report is due May 10th of 2023, and then it's annually thereafter. The report breaks down employee by race, ethnicity, and the sex in 10 broadly defined job categories. It's a lot of fun. The mean and the median hourly rate, so using the W-2 data, must be supplied. Reports also must include a breakdown by 11 U.S. Bureau of Labor Statistics pay bands. Employers with multiple establishments must submit a report covering each establishment. So hopefully you have somebody working on this, especially if you're of the employer size it's required to do so. You want to make sure all that information is in. So this kind of ties back, I'm sure, with the pay scale disclosures. So this applies to both private and public sector employers with 15 or more employees. It must be disclosed in any job opening, including those posted by a third party. So if you use somebody outside, you need to make sure they're doing it on your behalf. Must be disclosed to all applicants, even if they are actually interviewed. This just as anybody searching the website or looking for a job, it needs to be posted to them. A pay scale includes the salary or the hourly range in which the employer reasonably expects to pay for the position. We've had some comments or people asking, oh, okay, I'm going to just list $15.50 an hour to $1 million an hour, so I'm totally covered. Well, we don't recommend doing that. That's not how it should be. It's what you would reasonably expect to pay. If you're willing to pay $15.50 to $16.50 an hour, then that's what you're going to post. And only the base pay, salary, or hourly range must be posted. On the pay scale disclosures, so upon request, all employers must be able to provide a pay scale to current employees for their current positions. So this in turn is all your employees in your organization can have this access. So you want to make sure you have those available. Records must be retained for all job titles and wage rate history for employees for the duration of their employment plus 3 years. So you want to make sure you keep that information on file. The labor commissioner can inspect these records, and if not maintained, there is a rebuttable presumption in favor of an employee's claim. So if you don't keep the stuff, the employee is going to potentially win because you didn't keep your information. The penalties can be anywhere from $100 to $10,000 per violation. But there is a right to cure in which no penalty if all job postings for open positions have been updated. So you want to get them updated ASAP if you haven't done so already. All right, we're going to move along to the Fast Food Council, and Terry's going to give us an update.
Okay, another fun subject to talk about. This actually, the Fast Food Council regulation that came out this year, Jenna had mentioned earlier, it actually applies to fast food restaurants, and it applies to whether or not they're franchised or non-franchised restaurants. This kind of came about, labor unions have been pushing for a while, and I know you've heard in the media for several years now to get to the $15 per hour wage rate for all employees. Well, California, obviously, we're always ahead of the game, and so we're already at $15.50. But this regulation really focused on this industry. The act is also referred to as the Fast Recovery Act, and the official title is the Fast Food Accountability and Standards Recovery Act. To go along with the push with labor unions, it was actually signed into law by Newsom on Labor Day. The act actually creates, it's a council that is focusing on setting standards for fast food wages. And this year it was supposed to be put into place up to $22 an hour for 2023. It also focuses on hours and other labor conditions within the fast food industry. The council would consist of 10 members that would be appointed by the governor, and it comprises workers' delegates, employer representatives, and state officials. It also prohibits retaliation against workers for making any type of workplace complaints. Well, that's a lot, and there was a lot of uproar in regards to this regulation coming down the pipe. So The current status is that a Sacramento County Superior Judge actually put a block on the law, and that happened on December 30th. In the meantime, when it first came out, there was a lot of groups that were passionate about trying to block this. So what they did is they formed a coalition. It's called the Save Local Restaurants, and they filed a referendum over the bill. They had to gather signatures, and reportedly there was over 1 million signatures that were submitted, so that it puts the measure on the November 2024 ballot to ask voters to go ahead and overturn the law. The Secretary of State required 623,000 voter signatures in by December 5th. And like I mentioned, they already had over 1 million. So the deadline originally to verify the signatures was January 25th. We haven't heard anything regarding the January 25th date, but bottom line, it looks like it's going to actually go on the ballot for us voters to decide upon. Just a little bit more background, because it's kind of still in flux right now. Again, it applies to fast food chains if you have 100 or more establishments nationally. And the requirement is that you share a common brand, decor, marketing, or packaging. And it's defined as a restaurant that provides food and beverages for immediate consumption, either on or off the premises, to customers who order, select, or pay before eating. It gives the stipulation of ordering the items in advance, and then it also talks about table service. So I'm not going to go into a lot of detail. It's basically put on hold for now, but something that if you're in that industry, you definitely want to keep an eye on, and we'll provide updates as needed. Leave of absences, as we mentioned, gosh, if you can handle leave of absences in California, there's not only all of the federal requirements, but California always seems to have our own version of what we want to provide under those similar circumstances. Unfortunately, for those of us in HR, the federal and the California guidelines never seem to match. So we're trying to always figure out what the difference is between the two. So this bill, AB 1041, actually changed the scope of coverage under two of the different requirements in providing protected time off for employees. So the definition of family member was expanded under the California Family Rights Act, and also the Healthy Workplace, Healthy Families Act, which we know as the California Paid Sick Leave Law that all of us have in place. There's now a family member is a designated person, is considered under the family member umbrella. And this focuses on not only, we used to focus mostly on nuclear family relationships. Well, that's not reality nowadays. We actually have some modern situations as to what constitutes a family. So under the CFRA guidelines, any individual related by blood or whose association with the employee is equivalent to a family relationship could be determined as a designated person by your employee in order to take that time off. Under the California Paid Sick Leave Law, it's any individual identified by the employee at the time the employee requests the paid leave. So this affects a lot of you out there because most of us have California Paid Sick Leave guidelines that we have to follow. The interesting thing is that they didn't really define this clearly. So some of the webinars and things that we have been on with legal counsel actually even says it may even be your close neighbor. You know, if somebody grew up, it's a close neighbor, it's a roommate, that might be a designated person. The employer may limit an employee to one designated person per 12-month period under both of these, whether it's California Family Rights Act or the California Paid Sick Leave. There's a non-retaliation bill, SB 1044, for protected time off. There's some new guidelines. Basically, it prohibits an employer in the event of an emergency condition from taking adverse action against the employee for refusing to report to work or having to leave work because the employee has a reasonable belief that the workplace or work site is unsafe. So that's a lot of words in there. So I'm going to try to break it down for you. So bottom line is an emergency condition It doesn't include the health pandemic that we've been currently going through. But what an emergency condition might be is a condition of disaster or peril caused by natural forces or a criminal act, or an order to evacuate a workplace, a work site, a worker's home, or the school of a worker's child. So lockdowns, for example, that the kids experience. If we have fires and flooding is a reality for all of us that live in California. So that would be considered an emergency condition. Now, to define a reasonable belief, the standard is it's based on what a reasonable person under the same circumstances would conclude based on the knowledge of if the employer is complying or not complying with safety and health protocols, and whether the employee has received the appropriate training regarding those health and safety protocols. It doesn't apply to first responders, to healthcare providers, utility workers, and defense workers for obvious reasons. We need them around in case of an emergency. It does prohibit an employer from preventing an employee from accessing a mobile or other communications device for seeking emergency assistance, assessing the safety of a situation, or confirming with a person that they are in a safe situation. There are some exceptions for banking and employees operating specific equipment about using that mobile phone. But it's really important that if you have a cell phone policy out there where you restrict the employee from having any access to their cell phones during working hours, that you're going to need to modify those policies and be compliant with this new regulation. The nice thing too is that if there is an emergency condition, then the employee must provide notice as soon as possible to the employer that they're going through this type of situation. Jen, next slide. Okay, bereavement leave. There we go. So in California, they have been considering passing bills for several years now in regards to paid time off for employees. And it's gone back and forth whether it's going to be paid or unpaid for bereavement leave. So sure enough, this year there was one passed. It amends the California Families Rights Act, and it requires both private and public sector employers, if you have 5 or more employees, to provide 5 days of unpaid bereavement leave for an employee. There is a 30-day waiting period for new employees. The time off doesn't have to be consecutive, but it has to be within 3 months of the qualifying death. And it can be used for a family member. And this is how they define family member under this bill. It's a spouse, a child, a parent, parent-in-law, sibling, grandparent, grandchild, or domestic partner. The important thing is there's several of our clients I know that have policies out there already regarding bereavement leave. And so if you do, it may be a policy, for example, that you provide 3 days and then you define what that family member is, that an employee can take 3 paid days off. So what you're going to need to do is revisit your current policy if you have one in place. And maybe it's you provide 3 days of paid leave, and now to meet the requirement, you're going to have to provide the 2 additional days of unpaid leave. Also, you may have a policy in place where your family members don't actually expand to the magnitude to cover what these family members are listed here under the new law. It does state also that you can request documentation such as a death certificate, obituary, etc. I would just be sensitive to the employee if you're going to do that, but you certainly have the right to do it. The other thing is that if you are fall under the guidelines where you don't provide paid time off, but you provide the 5 days of unpaid leave, the employee does have the right to use their California paid sick leave to use for bereavement if it's unpaid time off. Okay, in January of 2025, the amount of wage replacement benefits has increased for low wage employees. For example, it increases, it used to be up to 70% of their regular wages that they would receive in benefits, and now it's going up to 90% of their regular wages. And again, both employers and employees contribute into the paid family leave and the SDI benefits. Okay, I'm going to turn it over to Jen, and she's more.
You muted yourself, but it's okay. I got it. All All right, so we're going to talk a little bit about retirement pension. I think I've spoken about this every single year that I give these updates, and it's the California state required retirement plan called Cal Savers. So by December of 2025, all employers with one or more employees should have a Cal Savers program in place and or a 401k or an IRA, some kind of pension retirement plan. There is a link here for you guys to log on to. If you've already got a 401k or an IRA that you're offering to your employees, you can exempt yourself out of this. If you have not, you can actually sign up for the program, and it needs to be offered to employees at the time of hire. It's a Roth after-tax program that's really just an IRA type account. And it's the employee's account. They can take it with them to any employer that they go. They'd sign up for their account, but as an employer, you have to do the deduction and whatever that looks like. And there's also some mandatory requirements that an employer has to sign up an employee automatically unless they opt out. So read up on that fun Cal Savers stuff. All right, we're going to talk a little bit about background checks and I-9 documents. So the criminal background checks, Senate Bill 731 amended the state penal code to provide criminal record relief. So this seals records of defendants that are convicted of most felonies on or after January 1st, 2005, if they completed their sentence, probation, supervision, parole, or any other terms of their conviction, and are not convicted of a new felony for 4 years. This will become effective July 1st. So background checks, they're going to have some information that will actually be sealed that we might not know about. And that's going to be if they've completed all their sentencing and completed all of what they were supposed to, then it's not going to be showing up on their background check. Criminal background arrest while off duty. So this is always kind of a hot topic because we have the internet, right? And we see little feeds that come through with the most recent people that might have been arrested or something of that nature. And you might find out that one of them is your employee and they haven't been convicted of anything yet, but yet you want to fire them and get them out of there. I caution you, you have to be kind of careful with some of that. Sometimes it's necessary, and absolutely, again, this might be a legal realm that you might want to reach out to your legal counsel to make sure they walk you through the process. But there are some things that an employer needs to be aware of. So the Labor Code section 432.7 provides that no employer shall utilize as a factor in determining any condition of employment, including hiring, promotion, termination on a record of arrest or detention that has not resulted in a conviction. So oftentimes you do a background check and they've been arrested for something, but the conviction hasn't happened yet. Kind of have to be careful and mindful of that. So employers are obviously permitted to ask questions around this. Oftentimes I reach out to the employee, I have a conversation and I say, help me understand, what was this arrest for, back in 2020, tell me a little bit about what happened. It's totally fine to have those conversations and understand the circumstances, because sometimes bad things happen to really good people. And sometimes you just need a little more information. So obviously you want to understand the nature of the alleged conduct underlying the arrest. Was it an arrest for a violent situation, or was it a property crime such as theft or embezzlement? This might have a modifying factor on what position you have them in. Are they your CFO? Are they your accountant? And they were, possibly being looked at for embezzlement. That might be a red flag. So you want to confirm the employee's job duties and the impact of the alleged conduct. Does the alleged conduct pose a risk because the arrested employee interacts regularly with coworkers? What if it's a violent crime? What if it's something that it's attempted murder or something of that nature, and you've got them working with a lot of other employees that maybe could escalate a situation? And we've got like a negligent hire situation where we've hired somebody knowing we've got these things and put them in a position that maybe is going to cause more harm than good. And again, does the employee handle money or was accused of money or property crime? Something to take into consideration, especially if you're in the retail space. All important things. Also determine how much work the employee is likely to miss. Sometimes this is a modifying factor as well. If the employee is released from jail shortly and able to return to work, is the employer able to hold the position open? Maybe is this going to be a 2-year process where they have to miss 1 full day? Do they have community service? There's all factors of having that conversation with your employee. Evaluate the impact on the employer. Is the arrest the employee has been arrested for an integral part to the business operation? Again, I bring like up the CFO or your accountant or something of that nature. Is this arrest public information that may damage the employer's reputation? Does the employer face potential civil liability if the employee returns to work? So these are all really great questions and ones that I would say talk to your legal counsel about, especially if you're faced with a situation. Sometimes you have to go risk and reward, and you have to say, is it riskier to have this person, or is the reward greater for keeping this person? And sometimes as owners, we have to make those decisions, and they're tough. But again, always reach out to legal counsel and make sure that you're on the right track. I-9 documentation or documents. So these have been updated. You want to make sure that you use the current forms. They are available. We want to make sure that you have the most recent updated I-9 forms and make sure you use the current ones. All right, we're going to have Terry wrap up some privacy for us.
Okay, the first law that we're going to look into has actually been in place for a while. It's the California Privacy Rights Act. And basically, this is a comprehensive consumer privacy act that has been in place for a while. Most of you have rolled out different things as far as letting consumers know how you're gathering their data, who you're sharing it with, whether they can opt out. Well, for a while, there was a part of it where it didn't apply to human resource data, and there was a carve out or an exemption that applied. Unfortunately, starting January 1st, that exemption went away, and now human resource data is a part of this. And employers need to put some safeguards into place and actually really look at data mapping to see where your information is coming in and where it's going. We've had to partner with our legal counsel as well to try to determine what that looks like for us. And of course, you want to go ahead and make sure that you're protecting personal information of employees, especially things like their personnel files. It's always been in place as far as their taxes, their tax forms, etc. This law, as I mentioned, applies to comprehensive data protections for human resource data. We have to disclose to applicants, employees, and independent contractors the categories of personal information that is collected. And we have to respond to any requests regarding employees' personal information as far as, how are we using that? Who are we sharing it with? We also are required to post privacy policies on how employers are handling HR data on the website. So if you're not, I'll go through a couple more requirements, but you're not currently having this in place and it applies to your business, it's something you're going to want to jump on right away. The policy has to include some certain CPRA provisions in contracts with vendors and let vendors know and give some stipulations on how they are handling HR data. It requires retention protocols to be in place on how long you're keeping that information. Employers have to comply with the new rights regarding the data pursuant, and I put the civil code on here in case those of you who love to read this type of thing might want to do a little further digging. But it also gives them rights to delete unnecessary information, except for information that we have to keep in order to comply with legal requirements. For example, wage and hour information, we're going to have to keep that for a certain amount of time to comply. It also gives them rights to correct any inaccurate information. And again, it applies to the civil code. There's a lot of details in here, so we're not going to go into all of that, but it's definitely something that you want to review. And then also for the employees, the right to get copies of some of the HR data. We already currently have in place, right, that an employee can have rights to their personnel files and their payroll records. Well, this is also additional information that they may be able to claim that they want to get a copy of. So who does it apply to? It generally applies if a business meets one of the following criteria. The gross annual revenue is greater than 25 million. They annually buy, sell, and share personal information of 100,000 or more California residents or households, or they derive greater than 50% of their annual revenue from selling or sharing consumers' personal information. The compliance begins, or it began on January 1st of this year, but it applies to data that you've already collected that was previous up until January 1st of 2022. Okay, some miscellaneous statutes and court cases that are affecting employers. Title 111 accommodations, or AB 1632. What this bill requires is for businesses that are open to the public for sale of goods that have restrooms for employees to allow individuals who have specific diseases that need to use a restroom or a toilet right away. And I listed the medical condition here, that you have to give them immediate access to a toilet that's used by employees. And it's required if it meets this criteria though. If it's a public restroom isn't immediately accessible to them, there's 3 or more employees that are working at the work site, the toilet facility isn't located in an employee changing area, or providing access wouldn't create an obvious health or safety risk to the requesting individual or security risk to the place of business. One of the things that we looked at too is, for example, if you have a small kiosk or something, obviously that might be one of the ones, businesses that, you don't have to let someone use your restroom because of all of those requirements in this second paragraph here. Could be safety, it could be public health because you're serving food or beverages. So it might be one of those businesses that doesn't have to apply. Again, these are things that you might want to check with legal counsel regarding. Also, the business can require for the individual to present a reasonable evidence that they have this type of medical condition, or that they're using a device. And the note can come from a doctor, a nurse practitioner, or a PA. Vehicle tracking devices. Again, talking about privacy, DMV piloted a program here, and it was in regards to digital license plates. Some of you may have seen those out there. I think Arizona and maybe Texas are the 2 states that currently offer these and have these in place. Michigan actually is the other one. But if this ends up being something that is utilized, it requires DMV to allow the technology to be used as alternatives to license plate stickering and registrations. It applies only to fleet vehicles, commercial vehicles, and vehicles operating under an occupational license that can use these alternative devices. It prohibits employers from using the devices, though, to monitor employees except during working hours and only if strictly necessary to perform their job duties. There is a disclosure or a notice that you absolutely have to provide to employees of any vehicle location monitoring. And there are several things that are included within this notice. The employee has to know that they have a right to disable the device during non-working hours. The notice has to include information about what activities are monitored, what data is collected, how data is stored, and what vendors the information is shared with. Again, it's only if you're under this program that has digital license plates, and DMV is still coming out with some of the requirements, but we want you to be aware that obviously they're looking a lot into balancing privacy rights of employers or of employees, along with the new technology that's available for employees out there, employers. Okay, workers' comp mandatory coverage. This is very interesting and probably applies to some of you out there, but it extends mandatory workers' compensation requirements to all contractors, whether you claim employees or not. Some people have independent contractors and they don't actually classify them as employees, which is another topic that we can kind of go over, a hot topic. But it applies to businesses that have these following licenses: a C8 concrete license, C20 HVAC, C22 asbestos abatement, and D49 tree service. So if you're in those industries, just be aware that there is mandatory workers' comp requirements now. And this applies whether the employee or person is working a day, a week, or whether they're working full-time. You also must file proof of insurance with a contractor state licensing board beginning January 1st of 2023. So that was passed obviously by a month now. As of January 1st of 2026, all California licensed contractors need to carry workers' comp insurance. And again, we provided the link here. There's a lot of lingo within the law and the language of the law. So here's a resource here that you can look into. But January 1st, 2026, it actually allows employers to make sure that they get these things in place, a little bit of time. Whereas those of you who are licensed under the first paragraph and within those categories, January 1st of this year, the date is already here. Okay, case law. Some of the case law, just, we live in California, we deal with wildfires, smoke, etc. So there is, Cal OSHA is submitting proposals to the OSHA Standards Board to increase some of the current standards regarding heat illness and wildfire smoke. And then again, the law is here, but those standards aren't out yet as of what we know, but something to be looking forward to on the horizon. Okay, and that's the fun for me.
Yay. Good job. We're whipping right through, and I've totally forgotten to ask if there's any questions. So I apologize if we have left you hanging in just complete despair because we haven't answered your question. I'm so sorry.
We have a couple, if you guys want to. So one about the cannabis, curious what the protocol is if an employee smells like cannabis during work hours.
Yeah, those are good questions because obviously that kind of goes down the reasonable suspicion, and you'd want to, do a whole reasonable suspicion type investigation, make sure your supervisors and people are provided. The hard part is that some people trim, right? Or they live in a household that's filled with marijuana and they smell like marijuana. It doesn't mean necessarily they're under the influence. So you're going to have to kind of walk a fine line. That's going to be it's probably going to be a hot topic. One of those things we'll have to consider.
Perfect. And then the other questions are kind of similar, and that is if they only have seasonal employees for 6 months at a time, how does that work with the 401k mandate? And then are part-time employees eligible for 401k?
Yeah, great question. So it's, any employee that's been with you 30 days, well, it's from time of hire. So yes, they would need to be offered it. They can opt out of it and they don't have to take the CalSavers program. Now, if you have specific requirements and you already have a 401k plan in place, you might have requirements that your part-time seasonal employees, they don't meet the hours threshold or the age threshold or the length of employment threshold. You've offered it to the employees that you have, and you can exempt out of offering those. You don't have to amend or change your current plans to accommodate part-time, temporary, or seasonal employees to accommodate that. So but if you're with CalSavers, you would still offer it. The employer doesn't have any responsibility with the contribution. So that's the good news. You're just required to make sure that their money from their paycheck gets into their account. And then that employee, when they leave you, they can take that account with them and they can start it at their next employer if they fall under those requirements of CalSaver. So hopefully that helps. All right, so we are just clipping along. I'm so impressed with us today. Usually this is like an hour and a half, hour and 45 minutes. We're going to get you guys out of here early and everybody's all raring to go and ready to update their policies and pull out that employee handbook that's 5 years old and go, oh my goodness, what in the world do I need to do? So here are some things for 2023 that we recommend you take a peek at and make sure that you update for this year. Obviously, with the California minimum wage increasing, if you're one of those employers that pays that, or even still, it has to be listed on your poster. Regardless if you pay more than that or not, it still needs to be out there. Family care and medical leave, your FMLA and your disability leave notices have been updated. You probably want to take a peek at those, especially if anybody should be paying attention to the pregnancy disability leave. Your rights and obligations as a pregnant employee notice, those have updated. California law prohibits workplace discrimination and harassment notice. Transgender rights in the workplace notice. know your rights. The workplace discrimination is a legal notice. This was formerly the EEO is the law. So that's been updated. Your rights under USERA notice need to be updated. This might or might not be on your poster, depends on where you purchase your posters from, but if it's not on your poster, it should be posted as well. Safety and health protections on the job, your Cal OSHA notice, they changed the hotline number. So you want to make sure your employees know how to contact Cal OSHA. So along with these 8 notices or posters, the unemployment insurance pamphlets have changed, as well as the sexual harassment pamphlets. So those have all been updated. These are all resources you can get offline. Typically, you can order online, you can have them sent directly to your business. Make sure your sexual harassment training has been updated, and that you're doing that every 2 years, 1 hour for your employees and 2 hours for your supervisors. Also, if you have or you employ minors, making sure that you do the mandated reporter, that's required as well as Terry mentioned some of those COVID guidelines and those COVID trainings that need to be done. Keep those things in mind. Sometimes those might be your safety meetings or so forth, but make sure that you've documented the process on that as well. A few other things that to keep in mind, obviously your pay scales. We talked a lot about that and making sure your postings are updated. You know, if you are required to do the data collection and you need to submit that by May, you need to make sure that you have all of that information available and ready to rock and roll, especially if you have to submit that report. But you also need to make sure that you have your pay scales and the positions for your job postings. You want to take a look at your policies. This is where you dust off the handbook and you say, what's our bereavement policy? Because that is definitely something that has changed or has now maybe enlarged a little bit. The California Family Rights Act, that is for all employers with 5 or more employees in California, follow CFR rules. Also it follows a little bit of the FEMLA language, but as Terry already said, California likes to do their own thing. So there's some certain things that have changed in regards to that. Paid sick leave, you want to take a look at that. FEHA and the EEO policies. Now there's been a name change. It's the Civil Rights Department. Update your CPRA document for all new hires. So Terry spoke a little bit about the privacy rules. This again might be something that you reach out to legal counsel if you fit into those descriptions of it being a business, that you might have to have this documentation out there for people and your employees to know how you handle their information. You'll want to update the CPP template or your policy. So this is your COVID prevention policy. As Terry mentioned earlier, you might have this alongside or with your IIPP. We recommend you kind of keep them separate, because if somebody comes in and wants to see your CPP, you don't want to give them your IIPP as well. You might just want to give them just the CPP and just focus on what the situation is at hand, instead of saying, here, take out all my policies. Let's look at everything. You know, it might open yourself up to a little bit more. But making sure you've updated that, as Terry mentioned, we're still waiting for a couple of finalizations on that. You can get these templates offline. They're pretty easy to update. It just takes some time for somebody to go through and be specific to your business, making sure that those are updated and that your supervisors are aware of where those are at as well, and that they've been trained on what to utilize those for. If you haven't done so already, make sure you order your 2023 labor law poster. It will take care of some of those notices that I went over in the previous slide. However, there's some new ones that you'll still have to hand out at the time of hire and so forth. But make sure you update those labor posters and get those up on the walls, back along with your IWC, your industrial wage orders as well. Those are all available as well, and you want to make sure those are updated. As well as maybe you've just updated your handbook. You want to make sure your employees have acknowledged that and have reviewed it. You know, they like late night leisurely reading and love to read nothing more than your policies and procedures on the operations of the office. So I'm sure they'd be happy to sign off on it. That is all that we have for you guys today. I know that's a lot of information. If you have any questions, feel free to put them in the Q&A for Miss Michelle to give to us. Otherwise, reach out to us.
Okay, so we have One more question in here. With the marijuana changes, are employers permitted to have policies prohibiting tobacco use, smoking, chewing while on the clock on the employer/customer premises?
Yeah, I don't see why not. Terry, do you? I don't see any reason why you couldn't have that prohibited.
Yeah, absolutely. And I know a lot of clients have that, like no, no
Safety.
smoking, or especially in vehicles for
Vaping.
safety reasons. Yeah, so definitely you can have that. In fact, there are some requirements as to how many feet in front of a building that, people are allowed to smoke, and maybe having some smoking signs put up so that people aren't close to your business and you're following the guidelines.
Yeah, I don't see why not.
Perfect. Okay, well, that is all the questions that we have so far. We want to thank, obviously, Jennifer and Terry for talking so much and going over all of these laws. I don't think we heard "hold on to your knickers."
No,
We do
I didn't
from
have
Jen.
anywhere good to put it in, or hold my beer, or hold my
Yes.
Corona.
Yes, so it's a brand new day. We'll see what phrase she comes up with next, since "hold on to your knickers" might be phased out. But again, thank you to all of you for attending. Thank you to Reading Chamber of Commerce for continually supporting our local businesses and helping us with putting on these webinars. Thank you to Shasta EDC as well for helping get the word out there. Obviously, it's always critical information, always super important, always overwhelming as well, as we know very, very well. So super thankful. I know I am that I have Jennifer and Terry to go to and not actually do any HR. And so it's a huge privilege to be able to have that, and a great resource for all of you as well. So if you guys do have questions, you need to contact us, please feel free to reach out. You can do that through our website. You can email at info@o2es.com. You can sign up for our newsletters online. You can call us. So we're absolutely here to help. Happy to work with all of you guys and with all of your HR and staffing needs moving into the future. Mr. Jake Mangus, do you have anything else you would like to say in closing?
I just want to recognize that Todd Jones with the EDC is in Phoenix, Arizona today, trying to bring airlines to the Reading Regional Airport. Otherwise, he'd be with us. So we're grateful for that partnership, as we said earlier. And I just want to echo all of that and thank you all for providing all that information today. I was taking notes, and I think my headache's coming back.
As long as it's not COVID.
That's right.
All right. Well, thank you guys so much for joining us. Thank you to our panelists and to the Chamber and EDC, and obviously the staff at O2 for putting this on. We appreciate all of you guys, and we will see you next year.
Sounds great. Thank you, guys.
Bye.
Have a great day.